along with Julia Janae, I'm Ted Rollins. We, earlier today, we were unable to get that feed of Shawn Stines, the sheriff in Kentucky, in as it was happening. However, we have it now. This is the arraignment. He, of course, is accused of shooting and killing the judge, Kevin Mullins.
This actually is happening in Carter County, where the court hearing is happening, but Lecter County is where the shooting took place. But of course, they had to move it just to keep everything unbiased and fair for this case where so many people know this judge and the sheriff. Let's go into that arraignment from the beginning.
Mr. Miller, do you believe that he's entitled to a public defender at this time?
I do, Your Honor.
And why is that?
This is a capital eligible case, and I believe that the cost of defending ethical defense of a capital eligible case will exceed his means.
Would you like to respond to that, Mr. Steele?
I would, Your Honor. A couple of things. One, I believe what he's telling me is that he's been out soliciting a client, which is obviously not allowed under our ethical obligations as attorneys. Two, even if he hasn't, if he has and he's been out trying to discern how much his financial capacities are, he's wasting state resources without an appointment. And this court is the party that appoints an attorney, not DPA, whatever division, just because they think he's going to need one.
Would you like to respond to that, Mr. Miller?
Your Honor, in cases like this, it is essential that a defense investigation start immediately, and I haven't solicited anything, but advised Mr. Stines of his rights, and if the court appoints us, we will represent him.
Is he still the sheriff of Leslie County?
At this point, I believe so. Letcher County.
Letcher County, I'm sorry.
Judge, I can't speak to that, and he currently is still the sheriff of Letcher County.
Yeah, well, I don't think he would qualify as an indigent defendant.
Well, sir, we're happy to, or Mr. Stines is happy to put any paperwork, file anything that would help the court make that determination. Obviously, the court is the one that appoints us.
Has he filed an affidavit for indigency?
Not at this point, Your Honor.
All right, we'll proceed with formal arraignment. Are you Shawn Stines?
Yes, sir.
You have the right to remain silent. Anything you say can't be used against you. Have your silence can't be used to find you guilty. County attorney must prove your guilt, or the Commonwealth must prove your guilt beyond a reasonable doubt. You have the right to call witnesses on your behalf. You have the right to cross-examine witnesses called against you. You have the right to a speedy and public trial by a jury of your peers. You have the right to an attorney. If you cannot afford an attorney, I'll appoint one to represent you. And you have the right to appeal any decision that I make. You're charged with murder, a capital offense here in Kentucky, a Class A felony, punishable by 20 to 50 years in prison, 25 years to life in prison, 25 years to life without the possibility of parole, and the possibility of the death penalty. Do you have an attorney, Mr. Stines?
I have not hired one.
Have you tried to hire an attorney? Have you spoken to any attorneys about taking your case?
No, sir.
And are you telling me that you don't have the means to, do you not have the means? Do you own a home?
Yes.
You own any other real estate?
Got a place in Tennessee, but I still owe for it with the bank.
Yes, but you know how much equity you have in your own home?
My home and my property is paid for.
And do you have an estimated value of that real property?
I think the PBA's got it on for about $45,000.
And what's your income?
It's based on statute. I think this year it was going to be 115,000.
Do you have monthly savings, bank accounts?
I had a check-in. Sir, it's my understanding that he's in the process of losing his job as the sheriff of Letcher County, obviously, and will not have income going forward. His family is not prepared for this eventuality. And again, I think the cost of defending one of these cases can reach well into this several $100,000.
You're entitled to, since you're charged with a felony, you're entitled to have a preliminary hearing within 10 days from the date of this arraignment. Do you believe you'll be able to obtain counsel to represent you on these charges within those 10 days?
I hope so. It's kind of hard, where I'm at, have contact with people I need to.
That it is going to take a considerable amount of money to retain an attorney to represent you on this capital offense. However, I don't believe you do at this time qualify as for public assistance due to the fact that you aren't indigent. However, based on the circumstances of this case and the fact that we do need to have a preliminary hearing within 10 days, I'm going to appoint the Public Defender's Office to represent you for the limited purpose of assisting you at your preliminary hearing. If and when this case does proceed to circuit court, the circuit court may require you to hire your own counsel. Do you understand that, Mr. Stines?
Yes, sir.
All right. I'll enter does he want to enter a plea at this time?
Your Honor, he would enter a plea of not guilty and request a date for preliminary hearing.
All right. We'll set the preliminary hearing next Tuesday, October the 1st at 1 o'clock in West Liberty, Kentucky.
Excuse me, Your Honor, we said October 1st at 1 o'clock?
Yes, October 1st at 1 o'clock in West Liberty, Kentucky at the Morgan County Judicial Center.
Thank you, Your Honor.
Anything else before we adjourn this hearing?
Not at this time, Your Honor.
Just one thing, Judge. I do have one thing, Judge, just for clarification. In regards to transportation for the defendant, how would the court prefer? I don't care to do an order for that to be done.
I was thinking that we would have state police post 8 transport if they would. I don't know that we'll need an order. I'll just request it, and if that's a problem, we can work out other transportation. Is that all?
Nothing further from our end, Your Honor.
All right. This hearing is adjourned.
Thank you. It would be to you, sir.
Yes, sir. Have a good day.
Sheriff Shawn Stines there pleading not guilty to the murder charge against him for the death of Judge Kevin Mullins. There's so much to break down from what we just saw, but we are going to get to a break, and next we're going to have our Matt Johnson, who is on the ground there in Kentucky, live next. You don't want to miss it.
Sarah Boone is charged with second-degree murder after her boyfriend suffocated inside of a suitcase.
He's in the suitcase still. There are multiple domestic violence incidents.
You two hitting each other.
Sarah. That's my name. Don't wear it up.
He told you, Sarah, I can't breathe.
George Torres locked inside of a suitcase, begging for help.
I thought he was okay.
The Suitcase Murder Trial. Live coverage starting October 7th on Court TV.
Welcome back to Court TV Live. We have our attention on Kentucky right now, where we just watched Shawn Stines plead not guilty to the first-degree murder of prominent District Judge Kevin Mullins. So much has been unfolding in this case since it happened.
And in Kentucky for us is Court TV Crime and Justice correspondent Matt Johnson. Matt, good afternoon to you. First of all, what stood out to you during this hearing?
Ted, Julia, nice to see you both. So what stood out to me, even though it was a Zoom hearing for the most part, for the main parties involved in this, including the special prosecutors and who appears to be the public defender and this defendant from the jail there was still drama. And there were 4 major takeaways. First time hearing from this defendant, this sheriff, who is still the sheriff that we heard. He's still employed by the county, still receiving that pension, has not resigned, has not been removed. So that's number 1. Number 2, we heard him plead not guilty by way of an attorney who actually isn't his attorney just yet. That's number 3. There was a lot of drama over the fact that he had a defense attorney by his side who wasn't yet appointed because he hasn't been declared indigent yet, which means that it hasn't been proven by the court that he doesn't have a way to pay for his own representation. He actually admitted to the court that he hasn't reached out to any defense attorney on his own right. And we also know that the next hearing, the preliminary hearing, is October 1st, well within that 10-day period that this special judge wants to move this along and get it into big court before it gets tried before a jury of his peers if it gets that far. So those are the main takeaways here. But let's go back to the drama, because there was a lot of drama today over the fact that there was a defense attorney, a public defender that was standing by his side. This defendant appearing in a gray jail inmate uniform. Right next to his side was defense attorney Josh Miller. And that was where the back and forth was, because, again, the sheriff, now turned suspect, has not turned in the proper paperwork saying that he needs a court-appointed defense attorney, but the judge allowing this so that it can move on to the next phase at this point in time.
Yeah, all eyes are on that next phase, Matt. Thank you so much for that live report, and we know we're going to be getting updates from you as this case continues to unfold. Let's bring in criminal defense attorney and former district attorney Matthew Mangino, who is standing by. Because, Matthew, a lot happened in that hearing that we just heard. Let's talk about the first thing that Matt mentioned, which is this issue of payment. We heard that the judge has, rather the sheriff, and the judge was asking the sheriff about his funds, his money, that he has a house that's paid off. What are the rules in terms of whether or not he can get a court-appointed attorney where essentially the state is going to have to pay for his representation?
Well, right. In every state, in every county, they have a process where, someone who is indigent, who cannot afford an attorney, has to go through a process of filling out an application, and they'll determine based on the application whether or not that person is in fact unable to pay for counsel and would have counsel appointed for them. We heard testimony, we heard the judge talk about the fact that he still is the sheriff, so he is still being paid. The process to remove him may be an involved process. I was involved in a very similar situation, not a homicide, but an elected official on the county level who was prosecuted while I was a district attorney. So removing someone who's been elected to a position can be a difficult process if they don't want to resign from that position themselves. So here, at first blush, it would appear that he has the resources to retain counsel for himself and would not be entitled to a court-appointed counsel.
Does he have to bleed his resources and then be eligible? Because, of course, if this is a capital case, that hasn't been determined yet. If it is, then he will rip through likely all of his resources. And that leaves his family, who is not to blame, we can assume, destitute. What is the guideline there? And when can a defendant receive counsel on the county's dime? Is it after they've already depleted their resources?
Well, if they have resources and if they have income, at least at the outset, they're not going to be entitled to a court-appointed counsel. They're not going to be entitled to free representation. Obviously, as they use up those resources that are available to them, they can reapply to have a court-appointed attorney. They can apply to have certain resources available for expert witnesses and things like that. But if you're employed, and he is employed right now, and you have some assets, a house, bank accounts, you're not going to be entitled to free representation. You're going to have to retain your own counsel.
Hey, Sheriff Stines, this was our first time getting a look at him. It sounds like he's not going to continue to have a job. He's expecting that they are going to fire him in the middle of this litigation over what he did. This was a man who was the bailiff at one point for the judge that he killed, Matthew. Your thoughts on, I know we don't know what the motive is. We didn't get any inkling of what that might be during this hearing, but do you have thoughts on where his defense might go in this case at this point?
I mean, that's an interesting question. You know, we know so little about what their argument was about in chambers. We know that there was, it's been suggested there was an exchange of cell phones. And then, you know, immediately after that, the sheriff shot and killed the judge. You know, we can only speculate what would be on those cell phones or what the substance of that argument was. But obviously, you know, there are some important issues that have to be, you know, sort of unpackaged here for us to really get any idea of why something like this would happen. You know, friends, people who just had lunch together, and one of those individuals would shoot and kill the other.
Yeah, and both with a very expert knowledge of the system and the consequences of shooting and killing somebody. Both the
inside of the courthouse.
Yeah, it's a fascinating case.